do the next.
If I give this to you, you get this snap away at will. I thought that may have been. There we are.
Good evening, everybody. Thank you very much for coming here. So my name is Shane Finn. I'm head of the Israeli Society, which is a society at the University of Oxford for promoting discussion on the rule of law, constitutional affairs and whatnot. So this evening we're going to be talking about the legal ramifications of the post-Brexit world. We have two very, very good speakers. We have Rory and Greg. They will be just, here discussing, what the implications will be for the British legal system, both in the lead up to Brexit, how Brexit happens, but also related issues like the potential repeal of the Human Rights Act and the replacement with the British Bill of Rights. So I'll just have maybe both our speakers just maybe introduce themselves. So Rory, if you just want to maybe say a few words about yourself and your interests.
Of course, thank you very much, Shane. My name is Rory Broomfield. I'm the director of the Freedom Association and its Better Off Out campaign. And so we were pretty involved with the EU issue, in fact have been for the previous decade. Of course, Brexit, so it's called, British exit of the European Union, has raised multiple issues, economic, democratic and indeed legal. And this is, I think, hopefully a starting point for this evening's discussion, because since the historic vote on June 23rd, multiple questions have been raised about the prospect of Brexit and indeed the implications for the UK's legal system. Now, just as a quick plug, I've just come out with this wonderful book called Cutting the Accordion Knot, which was republished from its original edition, published by the IEA in 2014. It's now published by the University of Enterprise Institute, and it's set to basically describe how the UK has become more prosperous and free outside the European Union. That's pretty much from me, but I would like to just thank the Disraeli Society for putting on this event today, jointly with the Freedom Association, and indeed our sponsors for this evening, which is the Federalist Society for Law and Public Policy Studies, a US-based charity that looks to promote legal discussion about constitutional rights, mainly in the United States, but I'm very pleased that they've decided to join the debate about the UK's legal future, both post-Brexit and with regards to the Human Rights Act and the British Bill of Rights.
Thank you very much, Rory. Greg, if you would like to say a few words of introduction.
Evening all, thank you very much for having me. My name is Greg Callis. I'm a barrister at 5RB, which is St James, which predominantly does media law, defamation, privacy, data protection, if you speak European Union law. I'm also a PhD candidate interested in conflict of laws, which has just got an awful lot more interesting in this country. And I'm also the Ombudsman at Financial Times, which hasn't joined any press regulator. But tonight I am here solely and utterly speaking for myself and no one with whom I've ever been affiliated or known or been educated by. I'm not a member of the Freedom Association. I came this evening, I was invited by Rory, who's an old friend. I was hoping to meet yourself, a real life federalist. So if there are any of you lurking in the audience afterwards, I'd very much like to meet you. But I'm essentially one of the sort of 7 people in the UK who's ostensibly neutral on Brexit. I spoiled my ballot. I was genuinely even-handed as to which way it went. So I'm not here because I think it's going to be wonderful or because I think it's going to be terrible. I'm here because I think it's going to be interesting. And that's what I want to talk about this evening.
Thank you very much, Greg. And again, I'd just like to thank our sponsors, the Federalist Society. Again, US-based charity doing an awful lot of great work, and they have very kindly sponsored this event tonight, and also a little wine reception afterwards. So we shall head our way to that when the talk is concluded. So, I think to kick things off, since you said, Greg, you think Brexit's going to be interesting, and you mentioned you're a candidate for a conflict of laws. So I suppose the first big thing people are wondering is, what is the first major aftershock we're going to see in terms of laws conflicting with each other once Article 50 is both invoked and then carried out 2 years after that? What are the first major clashes that we might see?
I think the big unresolved question, before we know the answer to that, is you'll all know that the Article 50 case is going on at the moment in the Divisional Court. And the two sides essentially are putting 2 very, very different cases as to whether the Parliament or the executive owns the prerogative is able to trigger Article 50. But one of the reasons that they disagree about which branch of government does that is I think there are very different ideas as to what exactly happens when you trigger Article 50 and the end point is reached, whether it's the 2 years or whether it's an agreement. Does all of European Union law in the United Kingdom essentially dissolve immediately? And that's very much the claimant's case. Lord Panic says, as soon as you reach the end, that's it. European Union law, all of those accrued rights, it vanishes as a matter of EU law, because it's only imported by Section 2.1 of the European Communities Act, and that imports essentially obligations on the UK. If the obligations aren't there, there is nothing, it goes. And I think the other school of thought had been essentially that Article 2.1 didn't bring in membership. It essentially applies EU law. It is Parliament saying the executive signed up to the treaties, Parliament's ratified them and applied them in domestic law, and they will continue to apply in domestic law until Parliament says otherwise. So the executive is within its rights to trigger Article 50 and take us out as a member state, but that does nothing to the state of domestic law decided by Parliament. And until the courts really resolve that question, we don't know what the aftershock will be. If Lord Panic is right, if all of this dissolves overnight at the end, there will need to be something in place. Fortunately, the court case is going to decide this fairly soon. There will need to be something in place. I know there are some very well-formed ideas about what that could be. But I think just for the sake of status quo, it is difficult to comprehend the scale of legislation, particularly subordinate legislation, for which we are dependent on European Union law. I don't mean dependent in that we couldn't do without it, but to understand the impact is more than one mind, perhaps more than one civil service can deal with. And I think most people think that there will not be a great aftershock, that there will have to be essentially sort of piece by piece repealing of the parts of European Union law that we found intolerable. The problem is that an awful lot of things that, as fast as we're ever going to be able to repeal them, will be new things coming in upon which we will also need to make a decision as to whether or not we'll be incorporating. I'm just going to flag up the General Data Protection Regulation as the biggest thing that is going to affect this country in the next 20 years. So there's going to be a compulsory review law that we're also going to have to make a decision on. And I think it's going to be very, very difficult. I think civil service capacity is an issue for the first time since the British Empire. And that's just because of the scale of the task.
How would you respond to that?
Well, I broadly agree with the idea that civil servants need to effectively re-engage and indeed maybe resources put forward to help the civil service encounter and indeed unwind or indeed go with the new environment that they'll be under. But in terms of the politics, the government seems to be pretty clear that after they invoke Article 50, whether or not they need to put that to Parliament or not, they will be starting introducing a Great Repeal Bill, hopefully to be an act, which would be repealing the European Communities Act, but also transporting all effective legislation onto the English and Welsh statute book, which in turn means that the repeal of all these laws and regulations that may or may not be basically what the British people want, and British people through Parliament want, can be done over the course of 5, 10, 100 or so years. Greg makes a very interesting point, though, that government will be grappling with Parliament will need to assess new laws and regulations coming in from outside at the same time. So this is where, actually, what my view is, and Ian Murray is in this, as I said earlier, this one for you, but basically come into it, because we are looking at a regulatory environment that's pretty complex. So we wish to set up a regulation reduction committee. That's a royal committee that sets aside from Parliament, but will give recommendations to Parliament, but allow Parliament in itself to get on with the job of legislating and assessing the new legal environment and the new laws in the meantime. Basically, the point here with regards to the new laws though, is whether or not the UK is a member of the single market. And that in itself is a big decision for the UK Parliament and the UK government, and indeed it's something that I personally believe was a decision made during the referendum campaign. And if the UK government does, in my view, enact the will of the people leaving the single market, then it has less of a task to assess all these new rules and regulations. Please come in. There are 2 seats there. And it can effectively get on with the job at hand. I'm just right. So the point here, I mean, Greg's assessment of the situation, I think, is pretty sound with regards to the task that government has politically in this legal environment. It has to assess the rules and regulations that it currently has on the statute book, but also has to contend with new laws coming in. That's why I believe it would be easier for the British government, indeed British people in the UK, to leave the single market and be free of the legislation naturally coming in, needing to naturally be assessed in Parliament. Instead, it would be able to do so at its will and have this regulatory commission, as I've laid out in Cutting the Gordian Knot with Ian Murray, to get on with the job of assessing what laws and regulations and what have you are impeding British, shall we say, economy in general, and give an assessment to government at a later stage as to what they might wish to repeal in the course of 5, 10, 20 years' time.
Thank you. So in terms of actually Britain leaving the European Union, I think there are 2 G's that haven't been really spoken that much about in the debate, but need to be remembered. The first is Greenland, the second is Gibraltar. So, in terms of the first, as Article 50 of the Lisbon Treaty states, when the article is invoked, there is a 2-year period in which a state has time to negotiate an exit from the European Union. If the agreement isn't reached within that 2-year period, once it expires, it's just out completely. The European Union just decides to drop it with no agreement, reverting back to World Trade Organization rules. Greenland, as part of the Kingdom of Denmark, left the European Economic Community back in the 70s. Greenland is very sparsely populated, has a very low level of economic activity. It shouldn't majorly be that much of a problem. It took 3 years for Greenland to negotiate an exit from the European Economic Community. My question is, what are there any legal safeguards that Britain could have to assure that there is a certain degree of leverage that potentially, politically, on the continent, you don't have a case where the first year of negotiations are all go well and dandy, and then let's say France decides to start dragging its heels. And then let's say Germany takes a turn to drag its heels after that then, and that we eventually end up having reached a 2-year period without achieving an agreement. Are there any safeguards that Britain has, not just politically, but also legally?
Well, the UK could ask the European Commission to extend the free trade negotiations. That's within the will of the government, as with the European Commission. The political element of this, I think, and again, it's something that's debatable, but it's a good approach for the UK government to say, look, we want to be good neighbours, we want to be good Europeans in this regard, we wish to have the best environment and trade with the European Union, and so we're going to approach this productively, and we're going to approach this with a considered view of having a free trade deal, which of course the European Union already has in terms of 43 odd trade deals around the world, from everywhere from El Salvador to indeed internally within the European community in Norway and what have you. So there are many different options, but of course At that point, if it doesn't go well, politically, if France drags at heels, or Germany, or never, or whatever, the Walloonian government comes in and says, no, we don't want this for whatever reason. WTO rules can apply, and indeed it wouldn't be the end of the world. I would refer people to John Redwood's recent blog for Comment Central, where he basically outlines the two benefits of the WTO regulations as it stands. For trade, because our currency has corrected to the extent where a 10% trade barrier would still mean that goods are 10% or even 20% in some cases cheaper than they were on June the 23rd. Obviously this fluctuates given the economic environment. But secondly, in terms of WTO regulations, this is a well-known, understood piece of, well, framework. And as a result, adopting WTO regulations will effectively create security and confidence and understanding of the position so that the business environment that may have gone through the rigmarole of a 2-year negotiation, up, down, side to side, the Walloonian government says this, the French government says that, whatever. It basically allows for business certainty in this case. So those are the two, I think, quite good aspects of the WTO regulations. Of course, there are other issues, but so that's well, not necessarily a safeguard, but that's the base platform. And I wouldn't say that if we weren't able to do a free trade union, it would be the end of the world, because as it stands, the US, China, and every country outside the European Union that doesn't have a free trade deal also trades and has access to the European market.
There's no safeguards. I think what's been terrifying this week is seeing that it's not just the 27 governments of the EU member states we now have to be concerned about, that we actually have to be concerned about the regional governments of Belgium, Spain, anywhere else that's capable of, well, the UK as well, capable of kiboshing a deal. The 2-year limit can only be extended by unanimity of all 27 member states, although strangely unanimity in that sense might be easier than agreeing a tailored deal. The one thing that's massively changed in the UK's favour is that as of March, a few years ago the EU Council moved from one form of qualified majority voting to a new form. The new form, but member states could still invoke the old qualified majority voting if they wanted to. They can't do that after March. And one of the impacts that has is it essentially makes it easier to pass things through qualified majority voting. It lowers the proportion of total EU population and voting weight that you need to pass measures. And with the UK not voting on its own deal, actually new qualified majority voting might not be that difficult to get stuff through the council compared to getting previously difficult things through the council. That comes with a massive, massive caveat, which is, as you said, Greenland's got the population of Croydon and all it cares about is fish, and it still took 3 years. What takes time is tailoring. So if the UK wants an off-the-shelf deal, single market membership, that can be agreed quickly. And if it wants an off-the-shelf deal along the lines of WTO membership, that can be agreed quickly. But if you want to tailor anything, if you want to upset the very carefully calibrated multifactorial balance of either of those sorts of deals, that will take 5 to 10 years. And that means a lot of countries agreeing, and just, to my mind, it just seems unlikely. I don't really mind what the outcome is, but it seems incredibly unlikely. One of the strange things that's cropped up in the Article 50 case is the court, particularly the Lord Chief, was very interested in whether or not the Article 50 notice could be revoked in any way. Donald Tusk's legal advisors have insisted that it can. Lord Paddock for the claimants, James Eadie, the Treasury Devil for the government, were both pretty adamant, I have to say entirely convincing, that it can't be. Because if you could revoke the Article 50 notification once given, it would make an absolute mockery of the provisions of the 2-year limit. It would be nonsensical to
keep repeating it.
Exactly, you'd keep withdrawing and you'd never... if that was the case, that is wonderful for the UK. We can sort of issue it for a year and 10 months and then take it off the table and then issue it again. We can play that game for 20 years. All the time we keep having a vote in the European Council on everything we don't really care about as a spoiler and using that for leverage. It would be wonderful. I just cannot see... That would be an EU question. That wouldn't be for the British courts to decide. That would have to go to the Court of Justice. And the Court of Justice does some pretty wacky stuff. But the idea that you can invoke Article 50 notifications, I just think it's just mad.
But not to sound apocalyptic, it's not as if the countries of Europe would want to gang up in Britain. It is a large economy, has lots of leverage in terms of people that live here, people that work in the Union, as a trade partner for several EU member states. They're not, it's not to say, just because there aren't any safeguards, it's not to say that the European Union will automatically say, right, we'll vote Article 50, that's it, you're off, you're gone, goodbye.
No, I don't think it's out of spite or anything else. I think the main motivation is pour jeune result. There's a French election coming up where Marine Le Pen is expected to come second, and she would take France out. Angela Merkel herself has to face elections next year. Nobody can be talking about a tailored deal. They can even be talking about a good deal. There are plenty of people, I don't entirely agree with Rory. There was one question on the ballot, it was about EU membership. There are plenty of people who wanted to leave the EU but wanted to stay in the single market. I actually think that's a perfectly respectable position to hold. I don't agree with it, but I can understand that there are people who both wanted and I think expected that to happen. They thought that would be the case. It was on sort of philosophical thing.
Not tied to the immigration issue. That was the whole point.
Well, I think that's the thing. I think there were certain forms of sort of go-get constitutionalists, if you like, who wanted to keep CJU in its box, so it would only apply to trade matters. So you wouldn't see the use of the Charter of Fundamental Rights in purely domestic social issues like privacy and free expression. You would keep EU courts to only determining really trade matters that were truly a matter of EU law, and the immigration would go pre-Maastricht. So it'd be movement of labour, but not of people with social benefits accrued. And you'd go back to pre-Maastricht, and that would be just enough to modify sort of enough levers that would sort of also be the 50-50 position.
But it doesn't necessarily chime with both the Prime Minister and the Chancellor at the time saying that a vote to leave would be quitting the single market. That seems pretty unequivocal. That was reinforced by Michael Gove and indeed Boris Johnson on the other side. So, my view is, picking up your point about people not necessarily understanding or viewing that voting would be leaving the single market. They maybe didn't engage in the arguments that were being made at the top level.
But there are also people talking about the Norway option and the Switzerland option. And I think it's very difficult to understand, what essentially they were saying, I suppose, was we want the single market, but we want an exception made for us on immigration. Unicorns. And if it was possible, who would possibly, I'd be against it, but not many people would be against it, but I just think a tailored deal sends out an incredibly dangerous message. Because Hungary would love a tailored deal. Poland would love a tailored deal. Most of Europe would love a tailored deal. The French got a tailored deal, they've got the EU and CAP. But everyone else wants a tailored deal as well, and the EU can't be seen to be doing it.
Yeah, of course. The tailored deal for the UK, the a la carte option, as Jean-Claude Juncker had said with his cognac and what have you, would be something that would be drawn out as well, of course, because again the negotiation for a preferred trade deal or free trade deal, the FTA, could have special interests effectively coming into it, and whether that be the UK government or the Germans or what have you. There's a real concern, I think, that if we don't get on with it and indeed embrace this new opportunity from both sides, that the EU can't do what it wants to do in integrating, like the President's report and the like, in the UK can't do what it could do, which is free trade deals with around the world and embrace the new environment.
Join the United States.
Well, I don't know whether that was on the ballot paper on June the 23rd.
Thank you very much. Okay, so I'll just put the question to our two speakers then about Gibraltar, which I just also mentioned previously. Where does Gibraltar fit into this? It's not a member of it's not part of the United Kingdom, but it is also part of the European Union, the only overseas territory to be so. Is it the case that potentially Gibraltar could be the reverse of Greenland? That you could have maybe Gibraltar stays in the EU while the United Kingdom leaves it. So I'll just leave you there with that on for 2 seconds, and I will now just vacate the chair to have the much more talented Brian Wall come in and take over. Brian is our moderator here this evening and is slightly delayed, but far better at this sort of thing than I am. So good to see you, Brian. I should let you take the chair and I shall vacate.
A round of applause for Craig.
Thank you everyone for, I hope that was a lovely start, and we've all been hearing, I'm sure, a lot from both our very respectable speakers here. I'd just like to start off this session with an open question to the both of you. There's often a lot of discussion that laws of the EU, previously prior to the vote on June 23rd, that in Britain a lot of our laws were dictated and controlled by the bureaucracy within the European Union. So the question now is, given that we've voted to leave it, what are the concrete steps and mechanisms through which we could achieve some sort of better legal autonomy, and what are the actual implications of the greater legal autonomy that manifest, given that we're now left technically, or not actually, the European Union in that sense?
Well, there's the big question, actually, I would say, about what happens with EU law pending Brexit. I mean, in terms of the invocation of Article 50, up until that point, we are still members of the European Union, fully fledged, with all the rights, quote unquote, and indeed the responsibilities, like funding the war chests and all that sort of stuff. Basically, we are a full member. Even after invocation of Article 50, what happens with regards to new EU laws coming through in the time being? It's a very prescient question. And in effect, there's a wonderful piece of work done by an associate professor at Oxford, and I think Greg knows what I'm going to, because he laid this bait via an email when we were discussing this. Basically talking about not paying homage to the EU judgments, and saying that, in effect, common law will take precedent throughout the process. And, as I understand, Associate Professor Ekin, I believe it was, Ekin's word, he was putting forward the case that, in effect, UK courts would be autonomous during this period, and and he advocated that both courts domestically, the high courts and indeed lower down, would not pay homage to the chapter and the word of EU law. So, in effect, his argument was to say, okay, we're invoking Article 50 through this process, we're going to leave, and therefore there's no necessity for the court to put in place to the chapter of the law, to the word of the law, the rulings and the deliberations of either the EU Parliament or indeed the ECJ itself. I don't know whether Greg views that as a convincing argument, but maybe...
It's a point of view. So take the people who were for leave for, these were purely constitutional reasons, okay? They don't care about economics, they don't care about migration, pure constitutional reasons. There is a strand of thinking that has never accepted the decision that EU law would be supreme over the law of member states, which is itself begat by, I'm sorry, I hate the ECJ-CJ thing, so I'm always going to refer to them as the Luxembourg Court, as the Supreme Court of the EU, and the Strasbourg Court, where I'm talking about the Human Rights Court. It was itself one of the Luxembourg Court, the EU law would be supreme over that of the member states, a sort of Marbury Madison power grab. And that's always been hated, it's been hated since Factor and I think the only thing that has been more hated by that branch of sort of sovereigntists was the decision against the UK by the Luxembourg Court, which essentially found that the protocol in the Lisbon Treaty, the Charter of Fundamental Rights of the European Union, wouldn't apply to the UK. They found that that was essentially not the proper construction of the protocol. And it's difficult, it is actually genuinely difficult to convey quite what an enormous step that was. If you think of British law over the last 40, 50 years having essentially three streams, let's take the Lord Denny Rivers and Estuaries argument. It, for 1,000 years, has had the stream of the common law, occasionally penned in by statute. Parliament stepping in to reform, sometimes on the advice of the Law Commission, sometimes not. But stepping in to guide the path of the common law that would flow freely. The first major change that we see then in 2000 is the Human Rights Act 98 coming in and direct effect being given to essentially the Convention on Human Rights. That itself was a staggering development in law. That sort of positive right, it was not really known to the common, wasn't really known to Parliament, and was itself enormous. But they're a fairly limited set of rights, and with the exception of Article 8, I think, were fairly recognisable within the context of English law. The Charter is a different beast altogether. EU law is the third big stream, and there's plenty of EU law that had direct effect, had nothing to do with rights. EU regulations had direct effect, and EU market peace regulations. EU law had direct effect, it had changed our law, and is written, I know it sounds ridiculous, civil law is written in a very different way. The integration, I think we have had a hard time in this country integrating EU law into our law, just because the language and the structure of it is different. We've had data protection from EU law since the mid-80s, and only now is it really starting to blossom and sort of turn into our course into something that people use every day, because it was just so impenetrable and European. And so the European EU laws, there's never sat well, I think, linguistically in all ways. Then to have the Charter, which had such an expanded number of rights, so you don't just have a right to privacy, but you also have your right to data protection. To have something as powerful and expansive in its language and wide-ranging as the European Convention, but to have it essentially imposed by a mechanism of supremacy capable of cutting through acts of Parliament in a way that human rights law had never been able to do. Those two things combined, actually, I think, were quite a remarkable shock to the system. You know, we had only seen, or we had very rarely seen, the common law can never set aside acts of Parliament. It almost certainly can't be done in common law. Possible question over Jackson, but it can't be done in common law. Even under the Human Rights Act, you get the Declaration of Incapacity, you can't set aside what Parliament has done. In EU law, you could, fact-attain being the first time it was done in the fisheries case. We've had it done 3 times in the last 18 months. Ben Caboose was an employment case because employment law is within the scope of EU law. Then we had it in Vidal Law as a data protection case, and we had it done again in the DRIPA regulations. And I think if you're an EU law supremacist, the one thing you would want more than anything else is an act of Parliament saying no longer is EU law supreme over English law, which is actually the position of the German Constitution for what it was always taken. At least in the matter of its domestic jurisprudence. And secondly, you'd probably want some sort of act of Parliament saying that the Charter of Fundamental Rights doesn't apply. Everything else, you know, saying that regulations now need to be applied domestically by Act of Parliament, just like directives are, that should probably follow, that can probably wait. But if you're a sovereigntist and that was your reason for leaving, it's the Charter is the ballgame, and it always has been.
So would you say, Greg, to put that in context, when Parliament, when the government puts forward a Great Repeal Bill, to have that as an amendment to it, as a clause within it, to say that this restates the sovereignty of Parliament, this means that court judgments, would that give the direction to domestic courts to say, no, you can't and you shouldn't?
You're going to pull me with the judges. I should declare an interest. I, as a judicial assistant to Sir Brian Levson, and I went to work for the Lord Chief as legal advisor just for 6 months or so. So I'm generally a passionate supporter of the judiciary, and as much as I have some sympathy with the Judicial Power Project, I think it's I think some of its criticisms are deeply unfair. Judges apply the Human Rights Act because they've been told by Parliament to apply the Human Rights Act, and I don't think we have judicial activists in this country in the same way as they have had them in the United States. And so I think the judicial power project occasionally, I think, suffers from a slight cultural tone deafness. I think there will be an adjusting period needed. It will be very, very strange for European Union law to no longer apply. But I don't think it would be anything like as strange if we saw a repeal of the Human Rights Act. I mean, I think culturally there, it took 5 years for judges to get used to the idea they could rely on the convention. It would take 20 years for them. And I don't think that's because they're activist or political. I think it's just so woven into our language. Whereas EU law, although it's cut through like a knife through butter, I mean, the effect is not confusing. It has been more limited in terms of its scope. The Human Rights Convention has affected every area of our law. EU law has only affected those areas which were traditionally within EU competence. And so I don't think it would be very difficult to get the judges weaned off Luxembourg judgment. I mean, the judgments are very, of course, but it probably would be something for a great repeal bill if that bill was there.
Because, of course, the big fear is we vote 50 and we look to leave the Luxembourg court and the like, and as a result, domestic courts say, aha, we need to fill the void. We need to step in to be much more active with regards to judgments or laws going through, because there's the view that, of course, government, the judiciary is independent, and of course, government may be making new laws, as it will be going through the next few years, that contravene basic tenets of, say, the Human Rights Act or what have you. So the view is that there's this potential of further judicial activism. So the reason why I mentioned about putting maybe a clause within the bill is just to state what would be seen as, for Sir William Cash or others, the blinding obvious, that Parliament should have the first and indeed potentially final say in terms of legislation.
In terms of EU law, I couldn't possibly disagree with that, and I'm not entirely sure that, for instance, reaffirming the opt-out that Parliament thought that it secured, and sort of an opt-out from the Charter, and even saying that the UK courts do not need to have regard to the supremacy of the Court of Justice. I don't even think you need to, I mean, I'd question whether you need to leave or have a great repeal bill for those clauses, but certainly if you're going to have a great repeal bill, that's probably where it starts. I don't think you'll find judges filling the gap on the Charter. I think the reaction of the judiciary, actually, if you read some of the early judgments, Mostyn in the Family Division, horrified when he's got a case in front of him and he has counsel explaining, yes, well, there was an opt-out, but it's been nullified by the Luxembourg. I mean, I don't think you'll find many friends of that sort of judicial activism on behalf of the EU Charter. I think it would be a very, very different business if we're talking about leaving the Convention and repeal the Human Rights Act. There, I think you would find because the Supreme Court's been fairly clear on this, that actually huge swathes of Human Rights Act jurisprudence has essentially now made its way into our common law. You know, a lot of the Article 8 stuff. We had, Wainwright in 2003 was very, very clear, there is no tort of invasion of privacy in English law. And a year later, they happened to decide Campbell and use Human Rights Act and British Contras. You know, 15 years later, we now have a full common law tort of the misuse of private information. It's been adopted. Human rights has got properly into the fabric of our law now. And so, if you had full repeal of the Human Rights Act and the Convention, you would find judges, I think, being forced to, whether they wanted or not, being forced to fill in the gaps and identify what parts of the Human Rights Act jurisprudence had made into the common law. They would find it very, very difficult to act without it. Parliament would have to set an awful lot of barriers, I think, for that. Less so for the Luxembourg and the EU also.
So I think as of now we sort of see two competing claims, right? There's a claim that says there'll be a massive void that's left in terms of judicial activism and individual recreation and interpretation of law, and there's a competing claim that says, look, in reality, conventions and existing principles probably mean it's unlikely that judicial activism would cause massive changes to the legal system. I would like to sort of shift the debate perhaps to an area that's not so directly related to the Human Rights Act, but would you say that there are other areas of the law where the judicial activism we fear could emerge and sort of change the way the landscape looks like, especially in terms of interactional or interactive law, like commercial law with respect to like trade relations or fishery designation in terms of the areas between UK and EU and European Union? on your conclusion?
Yeah, no, I see there's a real chance of that. The reason being that outside the European Union, when we leave, we'll be reclaiming a whole range of competencies that the UK hasn't had for nearly 45 years. And the point there is that, of course, in statutes, the rules and regulations that have been handed down from the EU and the like should apply through the Great Repeal Bill and Act, subsequent Act. But the point here is that courts will need to address these for the first time. In a similar way, Greg, to what you were saying earlier about civil service. It's the first time that they'll need to deal with certain things for 40 odd years. Gus O'Donnell, taking the civil service example, who was the head of the civil service in the Cabinet Office, said that it would take 10 years for the civil service to do a free trade deal because it hadn't done a deal before. In effect, there was no competence, there was no ability within the civil service to actually understand the mechanisms and the whys and wherefores. And this is the same thing when applied to the judiciary in this particular case, because whether it be fishing, whether it be energy in some cases, and the whole range of different legal frameworks, the UK will get the power back, and in effect, the judiciary will have for the first time be the check against the executive in these matters, when in the past it was ECJ or Commission in the European Union. So there's a real fear, actually, I would say, of judicial overreach in this case, because the judiciary would be fully emboldened in this particular case to review all these new regulations.
What does overreach mean as opposed to reach?
Overreach? It's a very good point, actually. The idea being, I suppose, the final arbiter of all these different matters is a considered view of English law. You have the independent judiciary, you have the Parliament, but the overreach meaning that before Parliament has considered new regulations and the like, it is in effect making the regulations. So overreach would be the courts within the UK framing the new laws before Parliament has actually granted the laws themselves.
I completely disagree with you. One of the interesting things that we were talking about earlier was the idea that as well as sort of a massive process of incremental repeal, that we'd also have to deal with the ever-growing incoming. And one of the things that's absolutely terrifying, you look at the number of statutory instruments, there's trebled in about the last 10 years. There's not less law going on, there's more law going on. And part of the reason for that is a shift from legislatures, in this country and in Brussels, from legislatures to executives, and more being done by Henry VIII, more being done by ministers, more being done by statutory instruments, and everything from the EU, largely emanating from the Commission.
Yeah.
There is a real problem here, a practical problem, whatever your ideology, which is Parliament, any legislative body, can simply not move as quickly as an executive body. So the speed at which the Commission is able to churn out new regulations will always vastly exceed the speed at which Parliament will be able to consider them. So there's a degree to which, at very best, you're going to have the executive rather than Parliament having to work out what gets implemented in terms of the forward-facing after we leave. Whatever you're going to have, there is going to be a significant lag in terms of the new, on top of what I think we've called the gaping void of the old. And the traditional, the most quintessentially British of ways of dealing with that is to essentially leave the field open and allow the common law to develop through the judiciary making decisions, and then Parliament intervening only on those occasions where they think the judiciary's got it wrong. So I don't think it would be anything like overreach for the judiciary to, if we have a large corpus of our be it human rights law or European Union law, plucked out. An interesting one where I think your analogy with the civil service or trade is good. Economics course. We didn't really have much competition law in this country before we joined the EU.